So I thought I would talk for just a minute about the worksheet from last time, because there are a few questions that seem to have sort of stumped people a bit. Let me pull up the worksheet real quick. I should have done that before we started. I didn't. Files. Okay, and we'll share screen. So so far, the worksheets that I've gone over, everyone has been good with number one, right? Anti-federalists, obviously, were not super excited about having a state or federal court system. They were certainly worried about federal power in general. And so the more institutions of federal government that existed, the less, if you think of power as like a pie, right? If we give power to federal courts, then we're taking away power from somebody, and that's probably going to be the states. So that was great. So number two, I've gotten basically every answer so far. So the question, if I'm suing the Denton Police Department, right, and I live in Denton, and I believe that they have violated both my federal and state constitutional rights, where can I bring my lawsuit?
Texas State Court.
I can bring it in Texas State Court, but do I have to bring it in Texas State Court?
No, you don't.
Why?
Because it's violating your constitutional rights.
Right, because I've alleged a U.S. constitutional violation. That is a federal question. So I could conceivably bring the case in either federal court or state court. And in fact, I would probably, we talked a little bit last time about forum shopping, I would probably actually want to bring it in federal court.
My group was sort of thinking like, if it was between, you would obviously want to do it in federal court because it would be a higher court reviewing your case, but just the courts looking at it, it would be like the higher court wouldn't want to be bothered with something as small if the state court could handle it.
That's an interesting thought. So in theory, a federal court could refuse jurisdiction, but only if it's hard for them to do, honestly. It would really only work if they could make a claim that this really isn't a federal constitutional issue. It's really only a state constitutional issue. So they would first have to rule on whether or not they have jurisdiction, or whether or not I have a claim under the U.S. Constitution. If I do, then I kind of get to pick for the most part. Okay. But that is an interesting dynamic, right? Does the federal court want my case? Probably not, but they may not have a choice but to take it.
Yeah, because we were kind of looking at the concept of new federalism, that if a law is broken in state and federal constitution, that it can be, if it can be solved by state courts, it will instead of federal court.
That was our fault. That was our lead too. That's where we were headed.
Okay, so that's a good point, and let me clarify that new federalism idea. So it doesn't mean that a state court should resolve it as opposed to a federal court. It has to do with which law they use. So if I brought it in a federal court And the federal court could say, hey, we can resolve this because of the Texas Constitution, right? Like it's clear that what they did, the Denton Police Department did, violated the Texas Constitution. Thus I win, right? Then there's no need for them to address whether or not it also violated the US Constitution, if there's no difference in terms of the type of damages I can get, right? So the new federalism is not so much about which court is going to hear the case. It's not about saying, oh, this should go to state court instead of federal court. It's about which law they apply. Does that make sense? That difference?
Yes, it has nothing to do with jurisdiction, just where they're applying from which law code, essentially.
Yeah, what's the basis for the decision? Are they
Okay.
going to bother with the federal question or not? And if they resolve it based on state law, they're going to be looking at decisions from the Texas Supreme Court as opposed to the US Supreme Court, because the Texas Supreme Court gets the last word in interpreting the Texas Constitution. So what you would end up with is a federal court issuing a decision where they're citing the Texas Supreme Court over and over again, and possibly saying, and we don't need to reach the US constitutional issue, so we're done, right? We're just not even going to go there. Does that make sense? But it would still, there's an issue, there's a difference, and I think the confusion makes a lot of sense, right? But there's a difference between choice of law and jurisdiction. Jurisdiction is, can you hear the case? Choice of law is, assuming you can hear the case, what are the standards that you use to resolve it? And new federalism is about choice of law. Make sense? Again, totally understand why there would be confusion there. That's why I'm here. My job would be really pointless if it were all super easy. So with number 3, most people, it seems like the people who got this wrong did one of two things. Either they missed the federal crime component, or they just weren't specific enough. So if I'm charged with a federal crime in Minnesota, what court is going to hear, and I'm convicted, what court is convicting me? What is the court I am in?
The district court.
Yeah, the 8th District Court.
I'm actually in for the initial trial, I'd be in the federal district court for the District of Minnesota. But since it's a federal crime, I wouldn't be in state court. I can only be prosecuted for a federal crime in federal court. So I would be, that would be the decision that I'm appealing, right? Because I've been convicted of a federal crime. So you kind of have to infer that means that I have been convicted by the federal district court for the District of Minnesota. And if I'm appealing from that court, who's right above them?
The Circuit Court of Appeals.
Circuit Court of Appeals.
For the 8th Circuit, yeah. So that's where that would be my next stop. And then if I lose at the 8th Circuit Court of Appeals, I could ask the US Supreme Court to hear my case. They will probably tell me no, but I could at least ask. Make sense? So number 4, I got a wide range of answers. Some of the answers were, we can't justify having federal judges overturn the decisions of federal elected officials. Fair. So that is certainly a position you can take. But I'm asking how, I guess I should have phrased this a little bit differently. How do we justify that, giving federal courts that kind of power? How do we justify having federal judges who are appointed and not elected making decisions that overturn decisions from elected officials. What is the justification for that?
We
My,
elect those officials to make those decisions.
that's what my group said as well.
Yeah,
We, by electing the people that we do elect, we given them our trust and judgment that they will appoint fair, just, and qualified judges.
Okay, so that is absolutely part of the equation, totally. That ultimately, and this, Jacob, is like a jurisprudential idea, right? That as long as the process getting them there was legitimate, then what they do is also legitimate. And in a democracy, we don't have a direct democracy. We have a representative democracy. We have chosen elected officials who then choose these judges who then make decisions, right? So there's sort of we have sort of delegated our decision-making to judges through this process. I think one of the other things that I want you to kind of take away from this question is that counter-majoritarian role that the courts play. This idea that we do have a representative democracy, but it is a limited democracy, and it's limited specifically by the Constitution. So in order to protect the interests of minorities, and here I don't mean like necessarily racial and ethnic minorities, but any minority group, right? Dissenters, communists and Nazis and religious minorities, anybody who's in sort of not the majority of society. In order to protect them, we have to have some non-elected check, right? We have to have somebody who is insulated from political pressure, actually preserving the value or the importance of the Constitution and preventing the elected officials from going to town.
So like someone that has power that's not based on a popularity contest.
Exactly. Yes. And so we actually, and we're going to talk about this a lot more next week when we talk about the tension between wanting judges who are independent, right? Who are not beholden to kind of the will of the people, but at the same time wanting judges who are accountable, right? Who can't just go off and do whatever the heck they want, right? There's some accountability for their decisions. Trying to strike that balance is really very difficult. The federal system tends to like strike that balance in favor of independence, and most states have opted to emphasize accountability over independence. But sort of the theoretical justification for judicial review is that in order for the protection of minorities, which is part of a liberal democracy, to be meaningful, you have to have some check on the popular branches. And then everybody had good answers for the most part about advisory opinions, as long as you were sort of, you can really take either position, right? You could take the position that, yeah, actually it would be super efficient to do that. And some groups did, or you could take the position that, no, we actually want courts to have a much better sense of the dynamics of an issue, right? We don't want them making decisions until we see how, for example, a law actually plays out in real life, right? We want them to be able, because of our adversarial process, we want both sides of the issue to be represented in court, and we want that both sides of the issue to have kind of complete knowledge about the reality of a law before we let the courts wade in. Right? So from a philosophical standpoint, you can absolutely take either side, and most people did. With respect to the material for this week on law school and lawyers, Was there anything about the reading that really stood out to you as being particularly interesting or surprising?
I thought how kind of young the barriers of entry to law school were, and just being around for the last 150 years essentially, and not having a whole lot of um, deeper history than that, just the apprenticeship model that was started in America, and it made me think about Lincoln being an autodidact and teaching himself the law and being able to use that to you know end slavery and by breaking pieces of our Constitution.
Right, by breaking pieces of our Constitution. Yes, that is what he did. Yeah, it is interesting. I think there's this sense that the law has always been reserved for people who are privileged. And to some extent, that's true, right? Like you had to, 200 years ago, you could apprentice to read the law, but you did have to know somebody to apprentice with. You had to be literate, which not everybody was. You had to have the time to, if you were out, tilling the fields or mining coal or whatever, you probably didn't have time to read the law. But nevertheless, like this sort of formal institution of law school is relatively modern in the US. We've had, there's a not so friendly rivalry between William and Mary and Harvard over who's first. Harvard definitely had the first dedicated law school. William and Mary had the first chair of law. They had the first law professor in the country. So, fight that out. So we have had some formal legal education in the US, basically, well, since before we were a country, right? But it was not the predominant path for most people until relatively recently. We do still have an apprentice program in some states. It kind of, people noticed it when who used it or tried to use it?
Kim Kardashian.
Yes. Yeah, Kim Kardashian, who's, again, think that illustrates some of the problem with the apprenticeship model. Obviously, she was able to find somebody to sponsor her because her father was an extraordinarily well-known attorney. And she herself has lots of money. So she is in a position of privilege, and it hasn't worked out so great for her. She has not. Did she finally pass the baby bar?
I don't think so. My wife said she didn't. She follows that pretty closely.
I know she failed at least once. I haven't been keeping up if she's passed or not, but
yeah, and this is just the baby bar, right? This isn't the actual California bar. This is just the thing that lets her keep going in her apprenticeship. So obviously the apprenticeship model is not super easy. And then there are other states. I don't know, Wisconsin may not do it anymore, but until fairly recently, you did not actually have to have gone to law school in order to sit for the bar in Wisconsin. But I think they've probably changed that. In any event, yeah, I think that is interesting. And that's something we, again, talked about last semester a lot, was the barriers to going to law school. It's incredibly expensive. And the LSAT is totally foreign to most people, right? That kind of thinking, that kind of test is not an easy sell for most people. So yeah, it's definitely still an elitist institution.
I thought it was interesting learning about the uniform bar exam. Maybe I should have known about that, but I didn't. And I was really intrigued by that because I was definitely under the impression that, I would have to retake it every single time that I moved states, which is a little daunting. So,
this is a fairly recent phenomenon. The okay, graduated law school a long time ago, 25 some years ago, but it didn't even exist then, right? There was no uniform bar, and certainly the number of states that have adopted it has just skyrocketed in the last 5 years or so. But it's fantastic. It also makes it easier to go to law school in one state and take the bar in another, because one of the barriers to that used to be some of the very state specific components of the bar. Like in Virginia, it was Virginia procedure, which is not surprisingly incredibly arcane. And if you don't go to a law school in Virginia, you're not going to have taken Virginia procedure, and you're going to really struggle with the Virginia bar. Texas, it's oil and gas law was always the big impediment, because again, if you go to law school outside of Texas and Oklahoma and Louisiana, you probably have not dealt with oil and gas law. So those sort of quirks made it harder to go, to law school in one state and then take the bar in another. And the UBE kind of gets rid of that, which is pretty spectacular.
Yeah.
And it makes it easier, like you said, to move from state to state during your career.
Yeah.
Or like you just said, it kind of, oh, I'm sorry, Emily.
No, it's okay.
Oh, I was just going to say it's not, yeah, you don't have to focus I can only have to go to school in this state because that's where I want to practice law afterwards, which, just like Emily said, I was kind of under the impression I knew there was some reciprocity, but it is rather limited is what I thought, not that 39 states or whatever now do it.
Yeah, reciprocity used to be a thing, like Minnesota, for example, had reciprocity with a bunch of states, but you had to have been practicing in that other state for 7 years before you could waive in without retaking the bar. So yeah, the UBE just makes life so much easier. What were you going to say, Emily?
Oh, I was going to say pretty much the same thing. It made me feel better about trying to figure out where I want to go. And I'll also say I really enjoyed watching the lecture from the law school. I have never seen a law school lecture before. It was, maybe that's not how all of them are. To me, it seemed less intimidating than I thought it was going to be. I guess I thought he was going to be kind of mean and scary, but he seemed really nice. So that was fun.
Yeah, I think that is actually a helpful thing to realize, that the structure of law school classes is intimidating for a lot of people, like being called on, that sort of thing is not fun for some folks. But most law faculty are actually perfectly lovely human beings. Not all of them, but most of them. We actually had a faculty member who was not a nice person. But in a school with probably 25, 30 professors, only one that people were actually legitimately afraid of. Everybody else was perfectly fine. Yeah. And I think it's good to see the way a law school class operates, with sort of tweaking, why is this case different from this case? Why is this situation different from this situation? Kind of playing with the margins, because that's how lawyers think, and it's not something you typically do as an undergraduate. So that's kind of one of the challenges is used to that. Any questions?
I kind of had a question just on billable hours. That's I'm writing, my paper assignment is lawyers in law school, so I'm doing a lot of research into billable hours specifically, and I'm I get it, but it seems kind of hard to have your whole day work 8 to 10 to 12 hours during the day, plan out every single minute of your day, and then go home and be this dinner didn't cost me $20, it cost me $270 because I could be working instead. Is there any job in which you're practicing law that you're not bound to the billable hours, like standard?
Yeah, I mean, prosecutors certainly don't have to worry about that. Really, honestly, any government attorney. So, working for the EPA, for example, you don't have to worry about it. If you're in-house counsel, so like if you're an attorney for Frito-Lay, right, and you just handle their cases, you don't have to keep, because you only have one client, right? And I think that's what happens when you work for the state or the federal government as well. You only have one client, so you don't have to keep track of your time. And then lawyers who work on contingency fee, on a contingency fee basis, don't have to track their billables because they don't bill. I mean, they bill for things like, the paper that they use, but they don't have to track their time the same way. But otherwise, yeah, everybody's tracking their billables, because I mean, that's how you figure out who owes what. Otherwise, you don't know.
Right.
And
Okay.
it is brutal. My friends who do it hate it, right? Sort of having to keep track of your life in 6-minute increments, and hit the stop button when you go to the bathroom and those sorts of things. It's really, it's something I think you have to get used to, and it's not fun.
It's that strict. I don't want that to sound like a dumb question. And I understand the ethics of it, but I didn't even ever think about a 6-minute break and going to the potty is,
And I know a lot of firms will have like quotas, like you have to reach 300 hours by the end of the month. So I can just imagine, like, if you haven't gotten even close to it and you have a week left, like you're scrambling and working, I don't know, 120 hours that week just to try and hit your quota. Like,
Yeah, and on the one hand, like you do actually break your time down. Each firm has their own policy about what the increments are, but 6 minutes tends to be pretty common. It's like kind of half of 15. So you have 8, is that right? Roughly 8 increments over the course of an hour. So if you do something for 8 minutes, that's 2 6-minute increments, even though it was only 8 minutes, right? You still bill that as 15 minutes, right? So like there's this game, right, where sometimes you're billing more time than you're actually spending because you round up for each of those increments. But if you do something, like if you are researching a new area of the law for you, right? It's like a type of issue you've never dealt with before, you can't necessarily bill all the time it actually takes you to work on that, because you don't want to penalize your client for the fact that this is new to you. So you actually may work in some cases more than you can bill. So there's this like weird back and forth, where sometimes you're billing more than you work and sometimes you're working more than you bill. But you have to juggle all of it. And yeah, and you are actually supposed to like hit the stop button when you go to the bathroom, when you go get a soda, when you take a smoke break, when somebody comes into your office and starts talking to you. You have to, there was a study a long time ago about the Postal Service that was trying to explain why there are high incidents of, or there were seemingly high incidents of workplace violence at post offices, right? Which is why we talk about people going postal, right? The idea is, and one of the stressors that was identified for postal employees was this management system that the post office implemented, where people had like specific paths across the office that they were supposed to walk, and a specific order in which they were supposed to move to do things in order to be like hyper efficient. And apparently people don't like to do that. People don't like to have their lives that regimented. And that's, for some lawyers, that is also a problem. But yeah, billable hours suck.
Are
And
those like the, I don't want to say the more lucrative jobs, but the jobs that obviously pay more are the ones that you bill your hours?
yeah, all the like big law jobs.
Like, oh yeah, I'd love to work in government, so I don't have to do that, but also I don't want to starve, so.
Want to do is work for the federal government because they actually pay pretty well. State, not so much, but feds get paid pretty well. Yeah, you know, there's this like phenomenon with big law jobs where the starting salaries will inch up in like Los Angeles and New York. And then like a year or two later, they'll bump up in like Minneapolis and Chicago and Dallas and San Francisco, right? So there's like this pattern of those jobs ratcheting up the base pay for a first year associate. I don't even know what that sort of standard is now. I mean, 20 years ago, it was 170 grand. So I got to think it's higher than that now. But like all of the people I knew who were heading into that market did not want to see that value, that number go up, even though it meant they were going to be making more, because almost inevitably that increase in salary came with an increase in the expected billable hours. And so, you know, it just got to be absolutely brutal at those big firms, the number of hours people work. It's a weird culture.
Can I ask a quick question about law school?
Yes.
So I was just curious, and this isn't something you brought up, but I don't really know many people that have gone to law school. So I know in college, obviously, it's typical to take like 5 classes and then you study 2 to 3 hours for each hour you spend in class. And then, you know, typically you maybe have enough time to get like a part-time job on the side. With law school, I think I heard that you take like 3 classes a semester, but what does the structure look like? Oh, it's still 5 a semester. Okay.
I mean, every school is going to be different, but typically, yeah, 4 or 5.
Okay, so you do the 5, and then I saw the like 40 hours of studying, which is technically what they recommend for undergrad too, even though I know people don't do that. So is it pretty common to also work while you're in law school, or do most people not?
Do not.
Okay.
I've heard that some people can get, just from the YouTube videos I've watched of people's like experiences, I've heard that 1L the first year, you definitely do not work, period. And then I can't remember if it's the summer between 1L and 2L or 2L and 3L that you start interviewing for internships at firms, which will hire you after you actually graduate. But some people were like, yeah, 2L and 3L are less work. So I worked a part-time job, but I don't think most people work at all during law school.
Okay. I mean, I wasn't planning on it, but I just didn't know if that was something that people have to do.
It used to actually be a rule. The American Bar Association had a rule that law schools had to forbid working during your 1L year. And they lifted that rule, but they should not have lifted that rule. Especially your first year, not only is it a lot of work and a lot of stress, but you're learning a whole new way of studying and learning. And that takes more time, right? You eventually get better at reading cases and you get better at learning that way. And so you can take the same course load your second and third year and actually have a little bit more flexibility. But by then you're doing things like law review and moot court and student government, and you're doing clinic hours your third year, and you've got all these other things that you're doing. So really having a job in law school, unless you go part-time, and I don't understand how people do it part-time, because part-time is not like half-time, right? It just extends it from 3 years to 4 years. So it's not, you're not really getting that much of a break. I honestly don't know how people do that. They do, but I don't know how.
Okay, thank you.
Yeah, please
Oh,
plan to not work.
yeah, no, I hope I don't wouldn't have to, but I also heard, and again, I don't know if this is true, but that for your first year, the classes you take are set. Like you don't choose it all. And then maybe you do for the rest. Is that true?
Mhm. Yep.
Oh,
Yeah, your first year, you don't get to pick your schedule at all. They just say, here, this is who you're taking, when you're taking, sit there. It's very regimented. And then usually your second and third year, you have a lot more latitude. There may be some required courses that you have to pick up either at specific times or at some point. Like some schools require that you take evidence before you graduate, but they don't care when. Or there may be like practicum classes that you have to take at specific times, but you have a lot more flexibility your second and third year.
okay, thank you.
And you can avoid like 8 a.m. classes if that's a real problem for you. Not your first year.
I was reading this article that I found for my paper that was comparing law school with med school, and how for med school students, there's a lot of programs put in place for, mental health specifically and or substance abuse. And just, reading through statistics of the mental health and substance abuse issues that law schools and lawyers face. I'm wondering why there's sort of a lag, that law school is like not really keeping up with the statistics.
I mean, for what it's worth, I think med schools have only come to that relatively recently. And so some law schools may now be following suit. That's certainly part of UNT Dallas's model is, for example, having quizzes and lower stakes assignments during your first year. So it's not all the one single high stakes exam at the end of the semester. So they're trying to make things a little bit kinder and gentler. So we may start to see that happening at more law schools, but I think a lot of it, certainly for med school as well, the resistance to that, even though it's so obvious that it's necessary, is the whole like, well, I did it, right? It builds character. So everyone should do it.
Right.
That's how we've always done it. What's the problem? So there's just that kind of entrenchment that happens.
Yeah, and I know it's kind of like, well, law school's on a curve to be like uber competitive, because in law practice, you're going to be competing with your colleagues for promotions, for partner, things like that. But I'm just like, if it's so toxic, like, why not change the culture? But I know this is like a bigger question. I'm just like, it's hard not to get frustrated reading the statistics.
It's alarming. It really, I mean, it's really bad. It really is. It can be a very unpleasant environment. And there are definitely schools that are more competitive, like where that culture is ratcheted up. And then there are places where that culture is softened considerably. So it's one of the reasons why it's a very good idea to actually visit a school before you attend, because they have very different cultures.
Mhm.
All righty, kiddos. You should probably, I know Jacob at least has got to actually drive.
Yeah, I'm about to boogie.
Yeah, everybody, if you get to your homes, hunker down. And if you find that you need anything over the next couple days, email me. I'm a
Hey,
Midwest.
you too. You too.
Oh yeah, no, I will. When I have problems, but I'm near campus and I have experience with snow and ice. So if you need something, let me know. Okay.
Awesome. Thank you so much.
Thank you, Dr. Watson.
Be safe, y'all.
Yeah.
Bye. Good night.
Bye.